that you didn't think that the dog had any dangerous propensities prior to this attack, correct?
Correct.
But you knew about the Halloween incident where the dog bit a young boy, right?
Yes, we talked about that earlier.
And you knew about the incident with the mailman, correct?
An incident I had heard from Wes, yes.
But you knew about it.
Yeah.
And you'd even seen that the letter that the post office sent West, correct, after that incident?
Yeah, he showed that to me much later.
And you knew that they stopped delivering his mail because they believed that the dog was dangerous?
For a period of time. They did resume mail delivery a few weeks later.
Sure. Mr. Ipsa, you believe that one of the main purposes in having a dog is for him to help protect your property, correct?
Sure.
But, and you believe that Chowser helped protect your property, right?
Yes.
But don't you believe that Queenie helps? You don't believe that Queenie helps protect your property, do you?
Well, I mean, she's, you know, I don't think a lot of people would get a setter as a guard dog, no.
And this is because she's a more gentle dog, correct?
Well, she is a gentle dog, sure.
And gentle dogs don't help deter people, do they?
Not often.
But aggressive dogs help deter people quite well, right?
I don't know about that. I'm no expert on dogs.
If you see a vicious dog, are you going to be deterred from breaking into your house?
Well, yeah, I might.
And you even, in fact, after you got rid of that vicious dog, your house even got broken into twice, didn't it?
Yeah, the
Objection. She's characterizing the dog as vicious. That's the central issue of the trial.
Sustained.
Once you no longer had Chowser, your house got broken into, correct?
Correct.
Mr. Ipsa, you testified that when you tried to get the dog off of Ms. Reeder, he actually turned on you and attacked, correct?
He did turn his head. I don't think he anticipated anybody coming up behind him.
And didn't he also nip at you during the Halloween incident as well?
Yeah, but he never actually bit me on the Halloween incident.
Well, going back to this incident, not only did he attack you the first time, but even after you and Becky were both present, he went back for Ms. Reeder, didn't he?
Well, I had actually thrown him in the pool yard. I'm not sure.
I don't believe at this time you had. If you want to go back to your deposition, you can check.
Okay, sorry. At which point in time then are you referring to?
If you came out the first time and you grabbed him and he nipped at you, maybe cut you up a little bit.
Mm-hmm.
And you said you couldn't control him and he went back for Ms. Reeder. And that's when you had to go back and grab him again. Correct?
Correct.
And that's when you got your major injury, correct?
Mm-hmm.
And when he went back from Ms. Reeder, she was not hurting him or provoking him at that time, was she?
Not that I recall.
Wouldn't you say that a dog who has attacked his owner on several occasions has dangerous propensities?
I'm sorry, could you repeat the question?
Wouldn't you say that a dog who has attacked his owner on several occasions has dangerous propensities?
If there was a dog who intentionally, aggressively attacked his owner on multiple occasions, I would say that that was vicious.
Wouldn't you say that it takes an aggressive dog to disobey his master who is there and trying to get him off of someone to then go and continue attacking that person?
No, not necessarily. I think that's just a territorial dog.
How is it a territorial dog?
Well, we have fences in the backyard, right?
But this is already after you've been there. He's already been attacking her. What does he have to protect once you and Becky are there and you're trying to remove him from the situation?
I mean, he is reacting to the stimulus of there being an intruder in the backyard. Intruder still in the backyard, dog is going to continue to react to the stimulus.
Even though his master is trying to tell him no?
Yeah, maybe.
Mr. Ipsa, you only spent 4 days in the hospital, correct?
Correct.
Are you aware that the plaintiff spent a whole week in the hospital?
I'm not 100% aware of that, but if you say so.
Just a few more questions. You testified that you were in the shower when you heard the screams, correct?
Correct.
And your shower is all the way on the second floor on the opposite side of the house, right?
Correct.
Yet you heard the screaming over all the running water.
Yes.
Now, when you turned the water off, you said you first heard the growls then. And you knew immediately that it was Chowser, didn't you?
Well, you know, I hadn't really considered the possibility that it could have been Queenie, but I guess it could have. That, you know, that's an assumption that later turned out to be true, so didn't really think twice about it.
If you want to look at your deposition, on page 3, line 38 through 39, it seems quite clear that it never crossed your mind that it was Queenie, correct?
Yeah, but then I later said that that would be possible.
But when you were in the shower, your first instinct was, oh my God, Chowser's attacking someone. Not Queenie, correct?
Correct.
And it wasn't even, oh my gosh, there's a dog outside attacking someone. It's my dog's attacking someone, correct?
Well, how many other dogs are going to be in my backyard?
How did you know that the dog was in your backyard when you were in the shower? Could it have been any dog outside?
I suppose that's true, Counselor.
Wouldn't you agree that if Chowser was more of a friendly dog like Queenie, it'd be strange to automatically assume that he was attacking someone?
No.
You don't think it'd be strange
No.
to assume that your gentle dog who's never had a problem with anybody is attacking someone?
Dogs can get territorial.
Ms. Tripp said not only did you instantly know that Chowser was attacking someone, but you actually thought that he was attacking Becky at first, didn't you?
Yeah, I mean, like I said, I was in the shower. I just hear barking and screaming. Like, I know that there are dogs in my house and one other person in my house.
Well, wouldn't you consider Becky as one of Chowser's masters since she was there all the time and helped take care of him?
Mistress, yes, but sure, we'll discuss gender at another time.
Oh, she was the dog's mistress.
Sure.
Is that okay? Interesting. So when you heard a scream and dog growls, the first thought that popped into your mind was that your very own dog was attacking one of its owners, correct?
Yeah, that's sort of where my mind
No further
went.
questions, Your Honor.
Can you redirect?
Yes, Your Honor.
Does she want this?
I don't know. Sure.
Seemed important.
May I proceed?
Go ahead.
We're driving up this street, South Glenwood, right?
Absolutely.
You're going to come from this direction, right?
Yes, sir.
Why is that?
That is a cul-de-sac. That's the only way into my street.
Okay, so as we're driving up from here, with the chain link fence and all, what kind of view do you get of your backyard?
Pretty good view.
You say you can see about 90% of it, 95% of it? What
Oh.
sort of percentage would you put on it?
I'd say you could pretty easily see just about the whole yard from the street.
So as you were driving up, you'd be able to tell if the dogs were in the backyard, right?
Sure.
Were the dogs in the backyard that day?
Yes.
Objection, lady. Overruled.
They talked a little bit about a city municipal ordinance, $30 little ticket you pay.
Sure.
Did you pay that when you were in the hospital or after you got home? When did you pay it?
I think it might have been while I was still in the hospital.
When you were in the hospital, were you on any painkillers?
Yeah.
Okay. So would you say that you signed that ordinance with a clear head?
No, I mean, honestly, it just looked like it was only going to be a little $30 thing. I didn't anticipate, being sued for thousands and thousands of dollars over it. So.
Have you ever had speeding tickets that cost more than that $30 fine?
Oh, yeah.
Now, you've lived with Chowder since 2004 or 5, around that time.
Mhm.
So about 5-6 years now.
Sure.
Have you, or anyone you live with, ever had any reason to believe that Chowder was vicious?
No, absolutely not.
Have you ever been told by anyone that Chowder was an obviously dangerous animal?
No, of course not.
No further questions.
Anything further?
No, Your Honor.
Thank you. The witness is excused.
Is that the defense attorney?
Thank you. We will take about 5 minutes.
May it please the Court? On June 6, 2010, Mead Reader's life was forever changed due to the defendant's failure to exercise responsibility for a dangerous animal that he owned. The issue in this case is whether the defendant should be liable for the injuries Ms. Reader suffered since he knew or could have known that the dog had dangerous propensities. The answer to this question is yes. The defendant acted with conscious disregard for the safety of other people when he allowed his dangerous dog to be loose in his backyard without first making sure that the gate to the backyard was properly closed. He should be held liable for his actions. We heard Ms. Reader testify today that she was performing her duties as a meter reader for the City of Columbia that Friday. When she came upon the defendant's house, she noticed that a car was in the driveway and that the gate to the backyard was wide open. Since Ms. Reader had been working on the block for some time prior to that attack, she knew that the defendant owned an extremely dangerous and vicious chow dog named Chowser. She also knew that the dog was never loose in the backyard unless the gate was open and people were home. Since all of her prior knowledge and experience told her that the dog must be inside the house, she decided to go ahead and read the meter. Since Ms. Reader was so scared of Chowser, would it have made sense for her to go into the backyard unless she honestly believed the dogs to be inside? Would it make sense for her to go open the gate on her own as the defendant claims? Of course not. Remember the defendant's testimony. He told us that his girlfriend had left the sliding door open that day. He also told us about how his girlfriend had a habit of forgetting to close the outside gate. Furthermore, he told us about how during the attack, he was unable to get the dog to stop attacking Ms. Reeder. In fact, he told us about how even the dog went back for Ms. Reeder even after he was there to try to subdue it. Interestingly, the defendant also told us that when he first heard the screams and growls, he instantly knew that it was his dog, and he instantly thought that it was attacking his girlfriend, Becky. This is because the defendant knew he had a dangerous dog. Otherwise, why would he instantly know that it was his dog involved in the attack? And why else would he assume the dog was attacking Becky? Finally, remember the testimony by the defendant's roommate, Westminster. He told us about 2 prior attacks involving the dog. He told us about how he wanted to get rid of the dog after it attacked the boy on Halloween, but how the defendant insisted on keeping it. He also told us that he considered the dog dangerous and didn't think it was a good idea for the defendant to keep the dog. Your Honor, the instructions state that you must assess a percentage of fault to the defendant if the plaintiff proves 4 elements, which she has. First, Your Honor, each witness today verified that the defendant was the owner of Chowser. Second, it's clear that the dog was possessed of dangerous propensities. He had attacked people on 2 prior occasions. He kept attacking Ms. Reeder even after the defendant was present. And the defendant even pled guilty to knowingly harboring an animal with known dangerous propensities. It is also clear that Ms. Reeder had not provoked the dog in any way because the gate was open, and when she saw the dog, she backed up slowly and tried to get out of the yard and calm it before it attacked her. Third, the defendant knew or could have known about the dog's dangerous propensities. The defendant knew about the prior attacks. He knew that Mr. Minister wanted to get rid of the dog because he considered him dangerous. He knew that the post office stopped delivering mail after the dog had tried to attack a postal worker. Additionally, the defendant also testified that one of the main reasons for having a dog was for protection, thereby proving that he knew the dog would attack if someone came close enough. Finally, as a direct result of the defendant owning this dangerous animal, Ms. Reeder was injured. This is obvious because if the defendant had not owned this dog and allowed the dog to be outside with the gate open that day, Ms. Reeder would not be injured. Your Honor, as you know, the burden of proof for this action is very low, and the evidence shows that Ms. Reeder has proven these elements to be true more likely than not. Because of the attack, Ms. Reeder suffered severe damage to her knee. She had to have surgery to repair it and still bears the scar. Her medical expenses totaled $48,503. This included 1 week in the hospital, fees for doctors and specialists, x-rays, the ambulance, medications, rehab. Ms. Reeder also missed a total of 1 month of work and had to switch jobs because of panic attacks she kept having when she tried to return back to work. Her lost wages totaled $2,500, and we ask that this amount be added into Ms. Reeder's damages. Ms. Reeder also suffered damages that do not accompany a specific dollar amount. She told us how every time she has to shave, she has to relive the attack. She's too embarrassed to wear anything that leaves her knee exposed, so she had to buy new clothing. Additionally, she has a permanent limp on that side and can no longer do things like run and play tennis, which is what she enjoyed doing prior to the attack. She also fears that she may have some sort of future medical problem with her knee. For these reasons, Your Honor, we ask the court to award Ms. Reeder a fair amount of money damages for her pain and suffering and for possible future medical expenses. Finally, Your Honor, we ask for a fair amount of punitive damages be assessed against the defendant. Punitive damages may be awarded if the defendant created a high degree of probability of injury and showed complete indifference or conscious disregard for the safety of others. Since the defendant was harboring a dog he knew was dangerous and a dog that had been known to attack before, he created a high probability of injury by leaving that gate open. The defendant testified that they tried to always keep the gate shut, that the dog would not get out and attack anyone, but he failed to make sure that that gate was shut on June 6, 2010, which is the only day that matters. Since the gate was open and he allowed his dog to be loose in the backyard, he showed a complete indifference or conscious disregard to Ms. Reeder and to other people in the neighborhood. He should be punished for his actions and to prevent him and others from keeping dogs they know to have dangerous propensities. The defendant will tell you that he thinks the attack on Ms. Reeder was all her fault because she went into the backyard and since there was a sign in the front yard warning people to beware of dogs. However, in order for the defendant to be successful in this argument, he has to prove that Ms. Reeder was negligent by failing to use the degree of care that an ordinarily careful person would use under the same or similar circumstances. Now, Ms. Reeder was not trespassing. She was legally on the defendant's property that day. She was also not negligent in her actions. She testified that she is 100% positive the gate was open. She also testified that her prior experience and current observations led her to believe the dogs were actually inside the house. Ms. Reeder is the only witness who actually looked at that gate on that afternoon and who is positive about its position. The defendant testified in his deposition that he knew the gate was closed in the morning, but did not know for sure whether it was closed in the afternoon. Mr. Minister was not at the house in the afternoon prior to the attack, so he cannot say for sure whether the gate was open or closed. Finally, Ms. Giles testified that the gate must have been shut because they always kept it shut, but did not testify that she saw the gate on the afternoon of the attack and that it was closed. Therefore, the only witness who actually saw the gate on that afternoon was Ms. Reeder. Since she is positive the gate was open, and since an ordinarily careful person would have believed that the dogs were inside, she cannot be found to have acted in a negligent manner. Furthermore, though defendant would like to rely completely on the City Ordinance 90-702, Ms. Reeder explained to us that this ordinance is not mandatory. It requires employees to make a quick decision based on their experiences. She told us that it was not practicable to return to the house, and as previously explained, her prior experience told her that there was no danger. Ms. Reeder was not negligent. The defendant was negligent that day. The defendant also claims that he did not believe the dog to be of dangerous propensities. But he should have. The dog was dangerous. It had attacked people before, and even Mr. Minister feared that it would attack again. The defendant cannot escape liability after the fact by claiming ignorance. He must take responsibility for his actions. The defendant has also brought in evidence of the fact that Ms. Reeder's insurance has compensated her for her medical injuries. The defendant hopes that this will persuade the court to lower her damages so that she does not get a windfall. However, I can assure this court that Ms. Reeder will not receive a windfall for this action because her insurance company will most certainly ask to be reimbursed for the money they have already paid to her. The defendant is trying to avoid having to pay Ms. Reeder for her injuries by relying on another source with deeper pockets, and it's unacceptable. The defendant also wishes for this court to take pity on him because of his own injuries and thereby reduce Ms. Reeder's damages. He believes that since he was injured by his own dog, and since he believes his injuries were worse than Ms. Reeder's, that he should be able to escape liability. But he is wrong. The defendant is liable to Ms. Reeder no matter what injuries he sustained because he was irresponsible in his actions that day. Do not consider him a good Samaritan just because he tried to get the dog off of Ms. Reeder. A good Samaritan would have made sure to keep the dog safely away from the general public. In fact, his injuries just go to show how dangerous that dog actually was. Your Honor, I ask you to remember that the damage has already been done here. Ms. Reeder's life has been forever changed. This is the only way that she can receive some kind of justice for the horrible attack against her. Give her the compensation she deserves so that she can try as best she can to put that horrific day behind her. Thank you.
Thank you, counsel.
Heard an interesting story. I've heard a lot of talk about whether the gate was open, whether the gate was closed, whether the dog is dangerous or not. But one thing we have heard throughout the entirety of today's trial is a story doesn't really seem to make a whole lot of sense. Doesn't really add up. Now, this case really boils down to two simple issues. Whether my client, Mr. Ibsen, knew that Chowser, knew before June 2006 that his dog Chowser was an obviously dangerous animal, and whether the plaintiff, on June 6, 2010, acted as a reasonable person. Examining the evidence, the answer to both of these questions is emphatically no. The only thing we know for certain is that the plaintiff's story makes absolutely no sense. The plaintiff should have known there was a dog. Why? Because this was her route every day. She knew who the dogs were. She knew that the dogs would be in the backyard. And additionally, as we heard numerous witnesses testify, a chain link fence, you can pretty much see everything in the backyard. If the dogs were there, she would have known before she entered the backyard. She saw the warning sign in the front, this warning sign that said, "Beware of dog." So she went to the front of the house and rang the bell, waited 10, 15 seconds, a bit, before she cavalierly entered the backyard at her own risk. And that's really what we need to identify, her own risk. The dogs were in the backyard, but Mr. Ibsen had absolutely no reason to believe, based on his personal history with the dog and his prior knowledge, that this dog would pose a danger to anyone. The plaintiffs put on their case, you've heard their evidence, and the plaintiff's case just doesn't make a whole lot of sense. They're trying to tell you that through this gate and out the other, a hose was stretched, preventing the gates from being closed. Yet their own witness testified that the sprocket to the hose was in the front of the house. That hose wouldn't need to be dragged through that gate. Not only that, Becky and Race testified to the same. All three of them live at the house. The plaintiff doesn't. She even testified on direct examination that she's not really sure about the layout of the house. She's not really familiar about where the things are in the house. Who would be familiar? The residents. That hose wasn't in that gate. That gate was closed. Now, the plaintiffs contend that the only person that saw that gate that day, the only person that's 100% sure, had to be the plaintiff. The only person that's suing for damages is also the plaintiff. Of course, it's in her best interest to say that the gate was closed. However, even if it were closed, it's a chain link fence. She can see into the backyard. She should have been aware that the dogs were there. In fact, she was. She said she saw Queenie, but didn't think twice about it, proceeded into the backyard anyway. And that's when I direct your attention to 9702. Dangerous animals. Before entering an enclosed yard or yard posted with beware of dog or other warning signs, city personnel should, whenever practicable, first contact the owner and wait until the animal is under control before entering the premises. My co-counsel asked on cross-examination, would it have been practicable for you to wait, knowing that there's a car in the driveway and you heard a shower running, to wait and see if someone would answer the door before you proceeded into the backyard? She said no. When pressed and given the definition of the word practicable, she said that she was incapable of doing her job according to city ordinance. And then plaintiff's counsel comes up here and tells you, and I quote, city ordinances aren't mandatory. The plaintiff wants to play fast and loose with the facts and fast and loose with the law so long as their client gets her money. Really, this case boils down to what's most convenient for the plaintiff. It was more convenient for the plaintiff to go into this backyard, check this meter at any cost because it was a Friday. At the end of a long week, she was done. She didn't want to keep working. We've all been there. I understand that. I've had long Fridays. But she neglected her duty as a city official, threw caution to the wind, ignored the fence, ignored the sign, failed to talk to the owner, violated the ordinance, and proceeded at her own risk. Just because it would have been more convenient. And now plaintiff's counsel tells you, well, city ordinances aren't mandatory. You don't need to really pay any attention to those. They're trying to play fast and loose with the facts and fast and loose with the law. You heard Mr. Minister testify today about Chowser. We heard today that Mr. Minister wanted to get rid of the dog. So he sold it to his roommate, Mr. Ipsa. He testified on direct examination this dog was so inherently dangerous and so vicious, he was so scared of him that he sold him down the hall. Must have been pretty brave. The fact is, Mr. Minister didn't want to get sued by meter reader. He didn't want to have any responsibility for the dog after any of the incidents that they allege occurred. Remember, Mr. Minister never witnessed any of these events. He never saw anything. All he knows is what he heard. And what we've heard about those instances is that they were blown way out of proportion. The mailman even told the defendant that he grossly overreacted, that he shouldn't have acted that way.
Objection, hearsay.
Goes to its effect on the listener. It's already been admitted.
Continue.
Mr. Minister simply didn't want the responsibility of a dog. He was only here to testify against Mr. Ipsa after he had been dropped as a defendant in this suit. There's a 5-year statute of limitations on this action. Mr. Minister knows that. He also knows that he's the property owner. Probably in his best interest to testify for the plaintiff so she doesn't bring this suit against the property owner if she doesn't come out victorious today. The most important evidence you heard today, far and away, came from the plaintiff. It came from her own mouth. You heard the plaintiff say she knew of the beware of dog sign. It was hanging in the front oak tree in front of Mr. Ipsa's home. She knew the dogs were in the yard, but chose to proceed anyway because, and I quote, she had never seen Chowser act up before. If she had never seen him act up before, she had absolutely no reason to fear him. But she proceeded anyway. Most importantly, she knew that she was supposed to wait and contact the owners of the home before and make sure the dogs were put away before the meter was read to ensure everyone's safety. She was aware of the city ordinance. She violated the city ordinance. She chose to proceed on her own because it was the most convenient thing for her. She ignored the fact there was a car in the driveway, ignored the fact that someone was in the shower, ignored the fact that the gate was closed, opened it, walked into the back, and was attacked by a territorial dog. Not an obviously dangerous dog, not a vicious dog, but a territorial dog. Today you heard from Becky Giles, the defendant's girlfriend. Becky told you she was home when the plaintiff came to read the meter. She told you that the plaintiff knocked but didn't bother to wait. Waited probably 10, 15 seconds before she just traipsed into the backyard as if it were her own home. Now, we're not contending she was a trespasser. We're only contending that a reasonable person should have been aware that there were dogs in the backyard, should have been aware of her duty as a city official to follow city ordinance, and that this plaintiff chose to ignore all those things. Most importantly, Becky told you that she never had any reason to fear Chowser. Chowser was her companion. Chowser was her friend. She loved that dog, and that dog loved her, and that dog had never hurt her. You also heard from the defendant, Mr. Ipsa. He told you didn't believe Chowser was a dangerous dog, described the dog as playful, as companion. He pointed out the dog would never hurt anyone unless provoked. And he talked about two instances. He talked about the incident in 2004 in which the mailman was a little bit spooked because the dog had came after him after the mailman came on the property. And he talked to you about an incident in 2005 in which a boy who was egging the house, throwing eggs towards the dog in the house, was attacked by the dog. Neither of these things, to any of us, if we think logically about it, seem inherently vicious. They seem like a dog protecting its territory. They seem like a dog responding. Poke a dog with a stick, it's going to bite. You throw something at a dog maliciously, it probably is going to come after you. And that's given with any dog. The plaintiff is asking for a lot in damages, mostly because they know Mr. Ipsa has a lot. Remember, she has no outstanding medical debt. Her medical bills have been paid. She didn't lose her job. She didn't lose her benefits. She didn't lose her retirement. She's not suffered the significant monetary loss she would have you believe that she has suffered. Now, I feel for the plaintiff. I understand. My client was injured as well. People have suffered serious injuries today, but the burden is on the plaintiff to prove to you by the greater weight of the evidence that these damages were caused by Mr. Ipsa, that he knew before 2006 that this dog was, and I'm quoting, obviously dangerous. Now, what does obviously dangerous mean? It means that it can be perceived by anyone who sees the dog. And we asked West, Becky, and Race, all, on cross or direct examinations, did you ever have any reason to fear the dog? All of them answered no. When I asked Mr. Ipsa on direct examination, have you ever, or anyone you know personally, anyone that's lived with a dog, ever been attacked by this dog? No. He'd never been told by anyone that this dog was dangerous. Ever. It wasn't obvious. It was lying in wait. A territorial dog that attacked what it perceived as an intruder, not an obviously dangerous animal. My client is not liable for these damages. In order to prove that he is liable, the plaintiff must have shown that Mr. Ipsa knew or should have known of Chowser's dangerous propensities. None of the witnesses who lived with the dog ever had been harmed. None of them had any reason to believe the dog would harm them. They felt safe. This dog was obviously dangerous. Why did everyone feel safe around him? This dog was obviously dangerous. Why hadn't it gone after anyone in the past 5 years? Why was it hiding in the garage on Halloween away from all the passerbys? This dog was not obviously dangerous. Liability, on the other hand, rests with the plaintiff. The plaintiff voluntarily and unnecessarily exposed herself to the risk encounter of Chowser. She violated city ordinance, ignored the warning sign outside the house, and proceeded anyway. The plaintiff would have you believe that this dog is vicious and it attacked her. But in the past 5 years, this dog has not attacked anyone. The plaintiff's trying to claim the dog is vicious, yet she told you today that she made it a point to get to know all the bad dogs on her route. She told you she never once saw Chowser act up before. She knew there was this city ordinance that required her to contact the owner, and she ignored
Counsel,
it.
you could sum up your overtime.
This case is simple. It's about failing to take responsibility. It's about failing to act as a reasonable person, and it's about a person, the plaintiff, who wants you to reward her for her failure to act reasonably, for her inability to do what she perceived as inconvenient.
Thank you, counsel.